Don't be cheap. If you stand to make $20, $30, $40,000 on an assignment or whatever it is, and the attorney charges you a couple $1,000, don't be cheap. Don't ask for discounts. If you're getting a great service and the attorney is going to help you win the case or preserve the deal, which means you're going to make 20, 30, 40K, do not be cheap and complain about attorney's fees. If you do, no attorney is ever going to want to work with you again, and you're going to ruin that relationship.
Hey, welcome to the show, guys. Today, I am interviewing Giovanni Borges. He's an attorney in Florida. He's an expert in litigation and probate, and he's known for taking on tough cases and helping investors solve major legal problems and helping families go through complicated probate matters. So, Giovanni, it's great to have you here.
Thank you, Julian. I appreciate it. I was just telling you before we started, I was looking at a lot of the other people that spoke on your podcast, and the content was phenomenal. And I'm not just saying that to butter you up before we start or to make you look good, but and that's kind of, I think, what brought me to want to speak on your podcast is just because of the content that you're putting out and the actual people that are speaking and providing a ton of value, just in terms of financing, real estate, and all the other topics that you discuss. So keep doing what you're doing, man. I enjoyed watching the interviews, and hopefully whoever's watching this gets a ton of value from it.
Yeah, thank you. And I think they will for sure, because we're going to deliver a ton of value. So Giovanni, before we dive into your story, can you help the audience understand a little bit about the scale of your work? Like, how many cases have you handled so far?
It's hard to give you an exact number. I actually looked it up right before we started the interview. So in terms of active real-life litigation cases, I am at, right now, over the past 6 years, 807 or 808. Now, that's cases that have been filed with the court. Either I was representing a plaintiff, or I was representing a defendant, or I was doing a probate matter. That doesn't include pre-litigation matters, things that we settled out of court, sending demand letters to certain parties, and basically there was probably hundreds of other cases that could have been cases and could have been filed with the court, but they were settled or resolved before. So if I had to give you a guess with how many of those happened, that's probably at least 400 to 500. So if I had to give you a guess, 1,500 is probably a solid number.
Wow, that's amazing. And roughly, can you tell us how much money you have helped clients recover or save over the years? If you could,
Yeah, obviously you can't hold me to this number because it's hard to say. And when we say recover, that the way I look at it is I don't do slip and fall and personal injury. I'm not suing insurance companies. So I don't want to throw shade on slip and fall attorneys because it's still hard work. You're still being a lawyer. They're still getting great results for their clients. But when I tell you how much I've saved my clients, this isn't just us suing insurance companies for a car accident and getting a check cut on a policy. This is real deal suing sellers that didn't comply or breached their contract, handling messy probates, doing estate planning for athletes. I mean, it's a different combination of recovery things. So the way I look at it is when I file a lawsuit or I have to speak to a seller or I'm suing another investor for tortious interference, for interfering with one of my clients' deals where they're under contract with the seller, there's a whole thing with that. If I had to look at the net profits of what my clients have made as a result of my involvement through litigation, man, we're talking north of 100 million at least.
Wow, man, that's big numbers. So looking back, what has been the highest achievements or results that you're most proud of in your legal career?
Honestly, man, I've done like a lot of complex cases. I've won cases, I've lost cases like any attorney. I think what I'm most proud of in my career is that I have genuine relationships with my clients. Most of my good clients that I've worked with for years, William Dennis, Oscar Quintana, two guys that spoke on your podcast and gave great interviews, I consider them good friends. Now, we're not best friends where we're hanging out with each other every weekend or anything like that, but most of the people that I work with, it's a long-term relationship where I'm helping them with all of their litigation, all of their probate, just deal-to-deal issues. And I think we develop a good friendship, along the business relationship. So it's nice to be able to work with people that you generally enjoy working with. And at the same time, me and Oscar, we settled a really big case. We went out, had dinner, just us two. He came out to my run club one day. William Dennis, I've been good friends with for a long time, and we became friends through business. So I'm not saying I'm best friends with all my clients, but I think being able to have a good relationship with your attorney and just being able to be straight and shoot it straight with your attorney and having important conversation without kind of worrying about what they're going to say, just having a fluid relationship, I think that's what I'm most proud of. If you ask most of my clients that I've worked with, and these are repeat clients that are mainly investors, they'll tell you, if I call Gio, he picks up the phone. If he doesn't pick up the phone, it's because he's in court, he's in a deposition, and he calls me as soon as he's out. And so my accessibility, I think, has helped a lot with that. But I think really just having a genuine friendship along with a very friendly business relationship, which makes it just much more practical and easy to work together.
Amazing. I love that. I love to hear that. And shout out to William Dennis and Oscar Quintana. They're doing great stuff. So let's get to it. So back to the start. What first pulled you towards a career in law? What was kind of that gravitating force for you?
Right. So my mom was a high school math teacher all her life. So naturally, as a kid, I kind of had an advantage. She would help me with my homework and do well at math, and she wanted me to do well at math. And so in high school, at my freshman year, I was taking geometry honors and algebra 2 honors, which were sophomore and junior classes. And by the time I finished high school, I was already taking calc, statistics, calculus 2, and I really didn't enjoy it. I was good at it, but it was kind of shoved down my throat, through my childhood and my mom being a teacher for most of the years. So I went to UCF for undergrad, and I initially started out in an engineering degree where I started out with civil engineering. It was great. Like, I was good at it. I was sitting there at the top of the class, but I didn't feel any type of satisfaction. I remember looking around in the classroom one day and looking at everybody else, and we're using a program called AutoCAD, which is essentially you have a computer and you're basically designing and crafting things through an online program. I'm looking at everybody, and they have smiles on their faces. They're enjoying themselves. They have passion. And I looked at myself, I'm like, I have no passion for this. Like, this doesn't get me excited. I'm not looking forward to my future, not in a pessimistic way, but it's like this, I don't feel anything from this. So I looked at the list of majors that UCF had, and I looked at all the majors, and I was like, man, none of this even gets me remotely exciting. I don't really know what I want to do. I know I got a decent brain. I'm somewhat smart, and I can make something happen. I didn't know what I wanted to do. And I saw law, and I was like, well, I never really wanted to be a lawyer. I was never one of those people that just argues all day long, and they were destined to be a lawyer, or they had lawyers in the family. And I saw law, and I was like, well, this looks like the only thing that's somewhat interesting. Maybe I'll become a mediator. Maybe I'll become a paralegal. I wasn't even thinking about becoming a lawyer. I signed up for law. I liked some of the classes. And I was like, well, there's nothing else that entertains me, so I'm just going to roll the dice and major in that. So I graduated from UCF in 2013 in 3 years with a Bachelor of Science in Legal Studies, a minor in Business Administration, a certificate in Public and Professional Writing. And then after that, I still wasn't convinced whether I wanted to become a lawyer, because I was like, man, do I really want to do this? It's a ton of money. You got to take the LSAT. It's another 3 years in school. You got to take the bar, all of that just to maybe get a decent job where you're making a little bit of money. There's a lot of unpredictables. And so I actually worked as a paralegal at a real estate foreclosure firm for about 3 years. And to this day, I still maintain all my connections with the people that I met there. Most of the stuff that I know now, I learned by being a paralegal. Not through law school, not through the bar, or anything like that. Most of the experience and where I'm at now is because of my experience as a paralegal. So I remember I was coming up on 3 years as a paralegal. I started out making $10 an hour. This is 2014. And I was living at my mom's house, and the firm, I was living in Pembroke Pines. The firm was in Boca Raton. I applied to a bunch of places. This was the only place that hired me. And at the time, $10 was a minimum wage, $10 an hour. I didn't care about the money. I wanted to get my foot in the door. I wanted to get experience. I wanted to learn. And so from Pembroke Pines to Boca Raton was at least an hour 10 drive each way. I did that for 2 months. It was too stressful. So from there on, through the end of my 3 years as a paralegal, I would drive from Pembroke Pines to Hollywood every morning at 6:15. I would wait for the tri-rail train to show up if it was ever on time. And it was never on time. It was always late. I'd get on the train, 40-minute trip up to Boca. I'd get off the train. I'd walk up the stairs. I'd wait for the shuttle, which was never on time. The shuttle would then drop me off about maybe a 15-minute walk from where the office actually was. Mind you, I'm wearing a shirt and tie every day, making $10 an hour. And so I would have to walk from where the shuttle dropped me off, get to the firm. I'm all sweaty, rolling up there. I'm all sweaty. I'm getting to the firm maybe at 7:45, 8. I would work till 5 o'clock. My boss would let me leave early. I would then wait for the shuttle to pick me up. Half the time it didn't pick me up, and I'd have to walk a mile or run a mile in my sweaty suit to get on the train, hope the train was on time, get home, and I wouldn't get home till 7:30 p.m. So I did that for 3 years. And again, I was making $10 an hour. Eventually, I went to $12 an hour, and I think $14.50 an hour. But again, I was looking at the long term of where am I going to go? What am I going to do with my life? And I became a really good paralegal. And there were some attorneys at that firm that I didn't think were all that bright. And it was a classic example of, wow, this guy can be an attorney. That lady can be an attorney. There's no excuse for me not to be an attorney, or at least take a shot. I knew I had to do something with my life and roll the dice. So I studied for the LSAT, which is basically like the SAT, but the law version, and you have to take that before you can apply to law school and get a certain score combined with your GPA. And the LSAT was really tough for me. I actually had to take it 3 different times before I could get a decent score enough just to apply to some law schools to get in. And so I also
Yeah.
took a prep class twice a week when I was working full time in Boca. I would leave early. I'd go to Plantation, take a 3 hour class 2 or 3 times a week just to study for the LSAT to get a decent score, all while living at home. And eventually, man, I rolled the dice. I got into Nova, and I went to Nova and graduated there and passed the bar. And I'm very long-winded, so I forgot where the question went. But I think you were asking me how did I become a lawyer? But
Yeah.
that's essentially my journey in terms of how I was able to become a lawyer. And again, I somehow just kind of fell into it, and I really fell in love with it once I started.
That's awesome. One thing that points out that sticks out to me is that you decided to pick a challenge. You saw the things that you were doing wasn't really challenging and it didn't excite you. So it seems like that you're more incentivized towards something that's a challenge, and that's great. I did have a question on did you decide to focus on real estate litigation and probate because you had worked at this paralegal as a paralegal for in this company before? Was that the reason, or did you make a conscious choice or decision to go in there because of a different reason?
I didn't, man. At that time, even though I had real estate experience, I just wanted to get a job anywhere I could. So when I was in law
Mm.
school, I applied to a couple firms. No one really got back to me. And my mom had an attorney prepare some estate planning documents for her one time, and it was a firm right next to Nova called Schroeder,
Mm.
Carnes, and Baker. And I randomly sent my application there. My mom was like, "Look, they're always busy. I think someone just quit. You should apply there. Just see if they recognize your name and maybe they give you an interview." And I submitted my resume, and my boss at the time, Ryan Schroeder, who was great, he gave me a shot, and I really learned most of what I know now, in addition to what I gained from that, from being a paralegal. They taught me everything, and so Ryan at the time really handled basically what I do now. And I learned from him. I was kind of like his protege. He was my mentor, and there's another attorney there, Larry Carnes, who was an older gentleman, but smartest attorney I've ever met. And I really learned under both of them while I was in law school, because I worked there for 3 years when I was in law school, and I actually worked there for a couple of years as an attorney after. And they were the ones that introduced me to the real estate litigation, the probate, the estate planning, title, and most of their clients that they worked with were real estate investors. And some of those same guys I met when I was in law school, I continue to work with today. So to answer your question, I didn't know. I just wanted to get a job. I didn't care what type
Yeah.
of law I was doing. I didn't want to do criminal because there's no money in that, and that's a little tougher. But I was willing to do anything else, just to get my feet wet and work my way up and hustle and find a solution. So I kind of fell into the real estate and the probate just by working at that firm, and I started to like it, and I was making great connections with clients, and from there on, man, I never turned back. It's just been continuous real estate investor, real estate investor, real estate investor, and everything that's followed suit from them.
Amazing, amazing. Okay, cool. So, okay, let's talk about probate. Let's do a little deep dive. So, let's break it down simply. Like, what is probate and why does it matter for property owners?
Sure. So probate's an administration that's filed with the court after somebody dies. Now, there's two different types of administration. You have a summary administration and a formal administration. As you can tell by the name, summary, formal, summary, what does that mean? Summarize. It's more quicker. Whereas the formal administration, the second type, it's more fancy. It takes longer. So there's two different types of
Yeah.
administrations. And with respect to property owners, depending on how a property owner holds title to the property, will determine whether the house or the property has to go through probate. Now, again, probate's it's an administration that's filed with the court, and essentially one of the heirs or beneficiaries is going to come in front of the judge and say, "Hey, judge, look, I was the named personal representative in the decedent's will, or I'm one of the heirs or one of the beneficiaries to the estate." And essentially, you say, "John Smith was my father," or whatever the relationship is. He died on this day. These are the assets he had. He either had a will or he didn't have a will. This is how we propose that all of the assets transfer to each party and these percentages. And the judge essentially has to verify all that to make sure everything's authentic. Also, the probate also opens up the door for creditors. So if that person, the decedent, and decedent's just a name for the deceased party, if they had creditors, those creditors can file claims against the estate and also basically enforce those claims sometimes against the assets that are in the estate. So really, if we're just talking about property here, it's very important to see how the person owned title to the property. And most of the time, people don't take proactive steps to adjust title of the house or the property, or they don't put it in a trust, or they don't have a joint owner on there. And most of the time when they die, their house has to go through probate in order for it to go to the heirs and beneficiaries.
Gotcha. Okay, cool. So when does a probate case become especially complicated or messy?
It becomes especially complicated or messy when you have multiple assets, if you have multiple heirs or beneficiaries, and then also if the heirs or beneficiaries don't get along. So it happens way more often than you think, where someone says, hey, dad promised me I would get the Lamborghini, he told me this or he told me that. Maybe you get what I see a lot is when you have someone that dies and then they remarry. And so they remarried a different spouse, but they had kids from a prior relationship. I have almost never seen in any probate that I've done where the new spouse gets along with the kids from the prior relationship. There's always some type of feud there. But what it really, like, for example, with Oscar's probates, his are very messy because a lot of the times it's not clear cut. The person dies, they didn't have a spouse, they didn't have they didn't have any children, they didn't have any parents, that survived them. And then the hard part is determining who are the heirs, who's entitled to actually be an heir to this estate. So it gets complicated when you have these people who died years ago and you have no clue who's next in line because they weren't survived by a spouse or children or parents or siblings or the basic heirs. And then alternatively, sometimes, and again, Oscar's probates, man, I could put on a clinic for how messy these things are. You may have it to where, let's say the heirs were the two kids, but the two kids died after the decedent or the owner died. So then it's not just having to do one probate for the deceased property owner. You now have to do a probate for the son and the daughter that died after the owner. And then at that point, you also have to determine who were the heirs and beneficiaries to the son and the daughter's estate. And then in terms of real estate investing or trying to buy the property, you may have under contract or you may have contact with, let's say, one or two heirs, right? But that's only so good if you really have 5 or 6 heirs altogether. And so the hard part is, especially for real estate investing, is finding all of these heirs, identifying who the correct heirs are with limited information from the family, and then getting all of them to sign your contract and to agree to sell the house and to sell the house for a certain price. Because there's always going to be someone that says, hey man, just sell it for this. I don't want to pay realtor fees. I'm okay with selling it for a lower price to cash buyer. And then you got someone else that says, oh no, I want to hire a realtor, and this is way below fair market value. So when you have the more heirs or beneficiaries you have in a case, the harder it is to sell, because the more people you have, the more, generally speaking, deferring opinions you're going to have about the sale of the property and the probate.
Wow. Okay, cool. So you kind of gave us a little bit of a breakdown. The next thing that I was going to ask was, can you share an example of a probate case that you handled that really stands out, that maybe it was very creative, or something that really pops the attention and the audience's mind?
I'll give you 2. So when I was doing one through COVID, we had the property owner or the decedent died in Florida, and he had, I think, 10 or 15 children who all lived in the Bahamas. Now the decedent died in the 80s, and again, of the 15 children, I'm not kidding, he had like 15 children. Of the 15 children that he had, like 12 of them died after him.
Okay.
So we had to do a probate for the guy that died in Florida. And then we had to do a probate for like 12 of his children that died in the Bahamas and lived in the Bahamas. So we had like one family member that was the glue in a WhatsApp chat who had to get us all the info about the 12 children that died. And then it's easy to get a death certificate in Florida, but in order to get a death certificate in a different country or even different states is incredibly hard. And this is during COVID. So in the Bahamas, they were very strict where nobody was allowed to leave their house for a certain period of time when COVID was very fresh, except for like the mailman. The mailman was the only guy that was allowed to go up and down the street and put the mail in the mailbox with the mask on. No one else could leave. And most of these people in the Bahamas didn't have email addresses. They didn't have internet. They weren't tech savvy. And that one probably took us maybe 2 years to get done. And again, so we were probably looking at 12 or 13 probates. And then there's a squatter in the property. The squatter was like a son of like someone else. And he was basically mooching and living there for free. And he tried to file something called adverse possession, which is when a squatter tries to become the new owner of the property, and that's really hard to do. And he had an attorney filing dumb stuff on his behalf, and he didn't qualify. Long story short, we were able to get it done, but it was incredibly, incredibly hard because it was during COVID. We had in total maybe 40 different heirs scattered throughout the Bahamas and some here, and like technology efforts, and then this is all during COVID. That was bad. And then I had one with Oscar that we just finished, and Oscar picked this up from another investor who tried to do it and failed after 2 years. We took a stab at it, and in this case, we had 8 different probates that we had to do just through the whole chain of title. And of the 8 probates, I think 3 of the 8 parties died in Cuba. Now, I'm not an expert on this, but I'm just going to paraphrase here. When you have an heir,
Yeah.
someone that inherits an interest in property, but they're a Cuban citizen or they live in Cuba and they're not a U.S. citizen, they're tech through the embargo and federal law, they're not allowed to inherit assets from the United States. And so there's a big restriction on that. So we did 8 different probates, and we knew who title went to. You know, there was a couple of heirs in Cuba, but our dilemma, and the judge wasn't all that familiar with the federal regulations and the Cuban restrictions because it's not very common. The judge was basically telling us, hey, you know, we need to figure out a solution here because these people in Cuba are not allowed to inherit the asset. How are we going to figure out a solution? So what we did is we had another attorney who does a ton of these Cuban probates and actually goes down to Cuba every couple of weeks because he has business relations down there. We had him appointed as what's called a guardian ad litem, where he essentially represented these heirs in Cuba, per se, or their interest in the property. He went to Cuba, met with them. He had to drive like 2 hours, met with them to sign all these documents and get them to sign these disclaimers, etc. And we were able to get it done. And basically the conclusion was that they technically inherited the interest in the property, but the money from the sale of the property, they're not able to access. It gets held in a restricted estate account for them until they essentially become a U.S. citizen. It's really messed up, and you know it's not fair to the Cuban people.
Wow.
Because we have that embargo and all those regulations. Things are always changing, and so the hard part was convincing these people to essentially say, "Look, we need you to participate in the probate, and you're going to get money. You're entitled to this money, but you're never going to be able to touch it unless you become a U.S. citizen." And you know, asking them to go and become a U.S. citizen is really tedious. So they essentially had to go along with the probate process just to help the rest of the family sell the property. And that one probably took a year and a half, and we got it done. And it was extremely complicated, but that was one of Oscar's files. So I could sit here for 5 hours and just give you horror story, but I don't want to bore everybody to death.
Amazing. And are you comfortable sharing? Can you share how much Oscar made on that deal once you guys sold it on the market?
I don't want to disclose that. If you ask Oscar and Oscar authorizes you to share that, then by all means,
All right.
I'm not at liberty to share that.
Right. No, of course. These deals, as people know, are complicated, but there's hefty profits that are made in these deals, and that's why they do it. You know, Giovanni wouldn't do it without it being worth his time, and neither would Oscar. So
Cheap. I'll tell you what, my fees for all that wasn't cheap. And as our buddy William Dennis says, the bigger the problem, the bigger the profit. And that's what a lot of investors are scared to do because it requires risk, upfront fees, you know, in terms of capital on attorney's fees, court costs, private investigator fees, etc. And there's a lot of risk, and not a lot of investors are willing to do that. But if you're willing to take a chance and obviously take the risk on these deals and spend a ton of money with no guaranteed outcome, it's high risk, high reward. You know, and that's what separates the average investor from the elite investors.
I can promise you guys, though, in the audience, that this probably was a 6-figure deal. That's all I'm going to say. But hey, let's talk about, okay, so for families and investors that are listening, you know, Giovanni, what steps can they take now to avoid major probate headaches later?
The biggest thing, man, and I've been on a couple webinars recently that I've been encouraging a lot of people because a lot of investors are finally like starting to focus on probate leads. And probate's there, man. People, you know, unfortunately, people die. You know, it's just a common lead, and I see a lot of investors like, you know, my heavy hitters always go to probate, but now I see a lot more of the common investor focusing on probate leads. The biggest advice that I can tell you guys is to learn the law. So what you want to do, and I'll send you the Florida statute after this if you want to put it in the description. But you want to be able to learn Florida law in terms of inheritance when there's no will. So when you're on the phone with these sellers, you don't want to have to get some information from somebody and say, okay, hey man, thanks for the call. Let me talk to my attorney. Let me run it by my attorney. Let me ask him all these questions because you know these leads, you know, if you take too long to get it under contract or you can't capitalize or execute or underwrite the deal when you're on the phone with these potential heirs and leads, someone else like Oscar will, who knows the law and knows that information, is going to come talk to those same people and make no mistake about it. As investors, you guys know that all those leads you guys are going after, there's another 100 investors calling them every other day. That's how the game is in South Florida. You're not the only one talking to these people. There's a million other people promising them a cash offer. They're going to close in 10 days and telling them the exact same thing that you're going to say. And so what I tell these investors, I tell them, I look up the law, I'll share the law with you, and learn it. So you want to be able to say, hey man, okay, your dad passed away when? Okay, who was he survived by? Did he have a spouse? Did he have children? Were the children from that spouse, or were they from a different relationship? Did he have a will? How many years ago did he die? How many assets did he have? Was the property his homestead? Okay, if he wasn't survived by children or a spouse, was he survived by his parents? Okay, if no to all that, did he have any siblings? You basically have to know how to go in order
Mm-hmm.
under the law to help identify who these heirs are. And so when you're
Mm-hmm.
structuring your contract with these heirs, you want to be able to underwrite to say, okay, hey man, based off of what you told me, assuming everything is correct and no one comes from the woodwork, if there's no parents and it's you and two other siblings, it looks like you're entitled to a one-third share. You're able to analyze all that on the spot. You can then underwrite the deal. Okay, hey, I need to be at this
Yeah.
purchase. I need to sign it at this price. You can then structure it to say, okay, if I give this guy one third, one third, one third, he's going to be entitled to this. And then okay, I got to factor in X amount for the probate attorney's fees and costs. You can tell them, hey man, look, when we do the probate, it's going to be a summary administration. We're looking at a month or 2 months to get it done. From there, maybe 2 to 3 weeks to close after that. And here's where we need to be on the purchase price and all that. So when you're able to give your seller all of that information on the phone, not only does it establish credibility, but you're separating yourself from every other investor that's calling them that doesn't know the answers to these questions. And so these people, when they're going through tough times and they just want to get rid of the property, if they have 10 people telling them the same thing, who are they going to want to sign a contract with? This is just generally speaking in life. You want to work with someone that's more credible and that you trust, that says, wow, this guy knows the law. He was able to explain everything to me, give me timelines and cost, and answer all my questions on the phone. Aren't you going to want to go with that person instead of the other 9 guys who said, oh, yeah, I'll call you next week and we'll figure it out? So having
Yeah.
knowledge of the law and the process is the best thing that you can do, because if you have to rely on going to your attorney or taking forever, time is money, man. If you don't strike when the iron's hot, you're going to lose the deal, and that could be the difference between you missing out on a six-figure deal. And I don't look at it just on a deal by deal basis. If we look at the longevity of our career, let's say you miss out on 2 deals a year, and let's say that you could have made 50K on the assignment, whatever it is. That's 100K of profit you could have made in 1 year. If we look at that over 20 years, my math isn't great, but what are we looking at? $2 million.
Mm-hmm. Yeah.
Over 10 years, we're looking at $1 million. That's a big spread because you didn't do your homework and take the time to understand the law and how everything works. So what I personally offer to some of my clients is we do a one-on-one, almost kind of like this podcast, and I do it through Zoom, and I just tell them, hey, ask me any questions you want. Once you're done, I'm going to show you the law. I'm going to show you the questions to ask and help you understand probate. And what I'm teaching is nothing unique. I'm just teaching you the law that you can learn yourself, but obviously I can help speed up the learning curve. But I always encourage people to invest in the knowledge of the law so you understand what you're actually doing and the right questions to ask.
Amazing, amazing. Yeah, that's wonderful. And so, what estate planning tools you recommend to help protect assets?
So one of the biggest things that people ask me is like, "Hey man, I want to make sure that my assets don't have to go through probate. What can I do?" So
Mm.
the main rule in Florida is if property is in a trust, it does not have to go through probate, regardless of who the beneficiaries are. So you can put it in a regular trust and a revocable trust. I usually tell people if it's a homestead property, put that in a revocable trust, and then if you have investment properties, put that in a land trust. And Julian, I noticed, I think one of your other guests, I don't recall his name, he sounded pretty knowledgeable. He was essentially saying how he keeps all of his properties in an LLCs, in separate LLCs.
Yeah.
Now, there's nothing wrong with that. If you have your property in an LLC, it doesn't necessarily have to go through probate if you have an operating agreement saying who inherits the interest in the business, if the main
Yeah.
owner has. A very good nugget that I tell investors, and they say, hey, what's the difference between having a property in an LLC and versus a land trust? With an LLC, as you know, you have to pay annual fees to the state of Florida every year to maintain the active status. So
Hmm.
don't quote me, it's like 100, $150, something like that. Not a lot of
Yeah.
money, but that adds up over the course of 10 or 20 years. Anyone in the world can go on www.sunbiz.org, type in the name of the entity. They can see the owners of the business, whether they're managers, members, addresses, who the registered agent is. They can see any amendments you make to the business. All your info is out there. Now, some people don't care, and that's fine. They say, hey, I don't care. That's that.
Yeah.
Me personally, I like, the less you know. So the downside to the LLC is you have to pay your annual fees to the state of Florida every year, and you have lack of privacy, where anyone can go and look up your info and see who owns the company. With a land trust, you don't have to pay any annual fees to the state of Florida. Generally speaking, you're only going to pay a one-time fee, maybe to an attorney, just to prepare the actual land trust document and a quitclaim deed to move the property in. For purposes of official records, if someone wants to see who owns the property, all they're going to see on the county records is that there is a deed transferring title from, let's say, Gio Borges to Julian Castle as trustee of the 1234 Street Land Trust. They're going to see a deed that transfers title to a trustee of a land trust. However, the land trust is not recorded in the official records. So they're not going to know what the land trust says, who the beneficiaries of the land trust are, when distributions are to be made, what other conditions are listed in the land trust. So cheaper, and you get more privacy. And in a world where everybody's suing everybody with litigation for no reason, always better to have privacy and have a little more info closer to the chest that's not accessible to the public.
That's really cool. And how much does a land trust cost? You said.
It's subjective, man. Like I usually charge, if it's a land trust and a quitclaim deed, I'll do something like $750 for the attorney fee plus recording costs for the deeds to pay to the county. That's usually like $30. So altogether probably under $800. But so you might find someone that does it cheaper. You might find someone that does it more expensive. But that's usually what I charge.
Okay, and these things you say there is no annual fee to it, right?
No, there's not.
Oh wow, that's really cool. And there's more privacy. That's something new that I learned. I know.
There you go, man. That's why I get paid the big bucks, right?
Yep. All right. Awesome. So let's talk a little bit about real estate litigation. All right. Let's talk in that topic. So when we hear terms like breach of contract and specific performance a lot, can you explain them in simple terms? Like, what does that mean, and what happens?
Right. So specific performance is a specific remedy that a party can seek under the law. So essentially, let's just use a buyer, for example, because most of the cases that I do, it's a buyer suing a seller. So if you have a contract that says that the parties agree to close, or the closing date to be on May 24th, 2025 at 5 p.m., and if the seller fails or refuses to close by the closing date, that's what we would consider a breach of contract. They didn't do what they were supposed to do. A contract is essentially terms and promises by each party. The seller agrees to sell the house. They agree to provide the buyer with access to the property during a certain period of time for inspections. They agree to convey clear and marketable title, along with whatever other terms are agreed to in the contract. The buyer, on the flip side, agrees to be able to fund the deal and to buy the property by a certain date. They agree to purchase the property for a certain price, right? So it's basically promises. And when one party doesn't comply with the promise that they make, the party who did what they were supposed to do can sue the other party who didn't do what they were supposed to do and seek specific performance through the courts. Meaning, hey judge, we signed a contract, we were supposed to close on the 24th, the seller doesn't want to close anymore for whatever reason, they breached the contract, therefore you're asking the court to sign a court order or a judgment basically requiring the seller to do what they were supposed to do under the contract. And it's not just with the closing date. So a lot of investors say, oh man, do I have to wait till after the closing date to file a lawsuit for specific performance against the seller? And the answer is no. I've done lawsuits, and I've won on these lawsuits in Broward County, actually, in front of Judge Bowman. We had an issue where the seller signed a contract. There's a 20-day inspection period, and the buyer, who was an investor, wanted to access the property so they could have their partners and other investors access the property so that eventually they could get a value and assign the contract to someone else. The seller refused to give access to the property. So I sued the seller, not for breaching the contract in terms of failing to close because the closing date hadn't happened, but I told the court essentially in the lawsuit that the seller was required to provide access to the property to the buyer for this duration of time. They refused to do so. They had no legal basis to refuse to do so. And so I sued them basically saying I want the seller to give my guy access for the 15-day period. And the seller fought me and hired a good attorney, and they said, oh, you can't sue for specific performance of just getting access, because technically the buyer's not ready to close. And we argued back and forth, and the judge agreed with me. And we actually got our attorney's fees and costs paid for by the seller at closing. So he had to do what he was required to do. And then everything that my client paid me, which wasn't cheap, the court costs, the process server costs, all the attorney's fees, which were hefty, were paid from the seller from his proceeds at closing, because the contract had a provision that said if litigation is needed, the prevailing party is entitled to recover its attorney's fees and costs.
Oof, let's go. That's amazing. Okay, that's wonderful. All right, cool. So that is a specific performance and breach of contract, right? So that's what happens. And All right. So when does it make sense for an investor to pursue a specific performance lawsuit?
Yeah, I usually tell one of the first questions I ask the investor, and I say, "What's your spread? Are you making $5,000 on your assignment fee? If so, is it worth spending a couple thousand on attorney's fees to force the seller to comply? If you're only going to make $5,000, it's probably not the best way to do it.
Yeah.
Maybe you try to negotiate with the seller, offer them a credit, but litigation really doesn't make sense at that point. Now, if they have a spread where they're making anything north of $20,000, I usually say it's worth filing the lawsuit for specific performance. But remember what I told you at the beginning of this podcast? I had 800 cases, give or take. I'd say of those 800, the ones for specific performance that I filed were probably at least 400 or 450 that I filed. I would say
Wow.
90% of those cases, of those 400, have settled or we've won. I'd say there's less than 10% where we lost or we had to dismiss the lawsuit because we just didn't want to move forward or it wasn't a good case or whatever it is. So most of the time, and again, every case is different. You got to see if the buyer did what they were supposed to do and they made their deposit. Were they actually ready to close? Was the seller the only one that breached? Most of these cases almost always settle. And so I encourage people, if you have a good spread, you stand to make a lot of money, don't just let this deal go out the window. You spend time and money, tons of hours, trying to get the lead, talking to the seller, getting it under contract, moving forward with closing, finding buyers, talking to the attorney. Now you have to spend thousands of dollars with the attorney to sue. Why would you let all that time and money go? And especially if you're an owner of a company and you have VAs or people under you that are working really hard. A lot of this is commission based with how a lot of my investors pay employees. It goes to show to your employees that, hey, I'm going to fight for you. I'm going to spend some money and we're going to sue this guy because he didn't do what he was supposed to do, and I want to see this go all the way through. And so that really helps instill a lot of confidence with the employees, I think, within the team. But also it shows the seller, like, hey, man, we signed a legally binding contract, because if I didn't perform, right, you're going to come after me for my deposit and go after attorney's fees for me, right? But if you don't perform, I'm not just going to let you go. And a lot of people, unfortunately, in today's society, when they have a contract that's signed, they don't want to cooperate with it. And unfortunately, you have to get involved sometimes.
Amazing. That's incredible. All right, cool. I actually have a case, but I don't want to talk about it here. But all right. Anyway, so what exactly is a partition lawsuit? And when does it usually come up?
Yep. A partition lawsuit is when you have one or multiple owners of a property who sue one or other multiple owners of the property to force the sale of the property. So, for example, you and I, let's say we partnered on a deal years ago, and you're living in the house and I'm not, and we were going to rent it out, or we had some deal between each other, but we're on title 50. And let's say, Julian, hey man, I'm running low on cash flow. I really need to sell this property. And you say, hey man, I'm living here. I really don't want to sell it. Let's work something out. And I say, hey, I don't have the patience for that. I want to sell it. What do you do in a situation like that when you have multiple people on title that want to sell or one person that wants to sell and someone that doesn't, right? Does it make sense that the guy that wants to sell pretty much has no remedy? He just has to wait until the other owner changes his mind about selling? That makes no sense. So Chapter 64 of the Florida statutes, if you go on Google and just type in Florida Statute 64, that lays out essentially all the elements and the requirements of the partition, of the requirements for filing a partition lawsuit. But essentially it's where one or multiple owners sue the other owners of the property, or one owner, and you're basically asking the court, hey judge, look, we're both on title. I'm allowed to seek the sale of the property. In this case, Julian doesn't want to sell for whatever reason. And 9 times out of 10, the judge is going to essentially force the non-complying parties to agree to the sale of the property.
That's amazing. And I didn't ask you, but what does it cost to sue for specific performance? And what does it cost to do a partition? I guess in the state of Florida, which is where you do it.
Yeah, I'll give you a typical attorney answer. It all depends, right? So I can tell you if a case, and again, every attorney is different. You may get an attorney that requires a $5K retainer, a $10K retainer. Maybe they do it on contingency. Maybe they do it on an hourly basis. And it really depends on the relationship with certain clients. So like I have a good relationship with Oscar and Will because I've worked with them many times. They send me a ton of business for years, so maybe I don't charge them as much money as I would with a new client who I have no relationship with. I can tell you just on average, at least for something like this, if it's uncontested for a specific performance case, meaning you sue the party, you serve them, they don't respond to the lawsuit within the required time, you get a default against them, you get a judgment, and they don't hire an attorney to fight the case, you're probably looking at under 5K for attorney's fees and court costs. So you have to pay the court a filing fee, you have to pay a fee to the clerk of court to record the notice of pendants, which stops or prevents the seller from selling the property to anybody else, and then you also have to pay the processor or sheriff to go and serve the lawsuit on these other parties. So I'd say under 5K is probably pretty safe. If it's litigated and there's another attorney involved, all bets are off. That number could go 20,000, 50,000. I mean, there's just a million different factors that can go into it. With the partition, if the partition's uncontested, and again, it depends on, is there one defendant or are there 10 defendants? Do these people live in the Bahamas? Do you have to hire a process server to serve them in the Bahamas, which is going to cost more money? So you have certain factors like that. If it's a standard partition that's uncontested, and we're able to sue like one or two people, and we get a judgment, maybe you're looking at under 7K. Because the court filing fees, they charge a little more. They classify it as a foreclosure lawsuit, even though it's not a foreclosure lawsuit. So the court filing fees are a little heftier there. So you're probably looking at 7K, ballpark.
Okay, cool, amazing. All right, and how can co-owners set things up to avoid running into partition disputes?
Usually they don't. If they wanted to be proactive, like if it's two investors, for example, I'll give you a better example. If it's two investors, they could put the property into a trust or a land trust, and they can come to an agreement that if one party wants to sell and the other doesn't, then maybe that party can give the other side an option for a buyout. So you can say something like, if Gio wants to sell and Julian doesn't want to sell, Gio has to get an appraisal done, send the appraisal to Julian, and then Julian will then have 30 days or 60 days to buy out Gio's 50%. And you would come up with the number, or the buyout number, based upon the value of the appraisal or whatever it is. But the parties, you're free to agree to whatever you want, but most of the partition situations that I handle are done through probate. So you have it where the owner died, and then it goes down to 4 or 5 kids. And the person that doesn't want to sell is always the person that's living in the house for free. So generally speaking, they don't want to sell because they're living in a house that they inherited from their parent for free, and they're usually not doing much. They don't work, and they're just kind of mooching there, trying to delay as much as possible. So most of these partition scenarios are usually probates, and that's where you have the multiple owners. It's not as rare where you have a Gio and a Julian who are businessmen that are on title and they can't come up with an agreement on the sale. Because usually, if we're involved with business, we'll figure something out. Hey man, let me get this property, or I'll send you 100K on this next deal. Like, it's a little easier to negotiate something between investors or if not traditional people. But usually it's very common on probate deals where multiple people inherit their interest from the deceased property owner.
For sure. Yeah. Okay, that's great. All right, and another thing we wanted to talk about, which is what is a quiet title action, and when should an investor consider filing one?
A quiet title lawsuit is essentially a lawsuit filed by an owner of a property against another party that has some type of encumbrance on a property. So meaning a property owner may sue a lender who has a mortgage on the property to try to wipe it out. Or there might be another type of lien. Like, for example, I'll see squatters file stupid liens that are invalid under Florida. And they record it against the property saying they're the owner or they're entitled to this, and that. And when you go to close, the underwriter ensuring the transaction says, hey, we can't close until there's a release signed by the party or there's a court order striking that. And so quiet title, basically, quieting title to the property. You're basically bringing balance to where title of the property is clear of whatever defunct lien is on the property. So most of these that I file are for what we call zombie mortgages. So zombie mortgage is usually a mortgage that's at least 20 years old, and a lot of times it gets brought to my attention because the buyer that's closing, the title company that's handling the closing, they will try to request a payoff from the lender or the servicer, and either they get no response or they're unable to locate that party or any contact info because a lot of these companies went under or bankrupt, or they wrote off the loan and they're not accessible, and so the closing can't take place until they get a payoff. And so when they're unable to get a payoff, we usually look at the mortgage and say, okay, how old is it? How many times was it assigned between different investors? The next thing we look at is the property taxes. I know our buddy Will was talking about this on the podcast with you. If you see that the lender is not paying the property taxes on the property, that's a major green flag, meaning that they probably are not going to enforce that mortgage, because if the property is sold at a tax deed auction, the mortgage gets wiped out completely at the time of sale. So if the lender is
Yeah.
owed $500,000, generally speaking, the lender will actually pay the property taxes as part of the mortgage payment for the owner. So when the owner, like I have a
Yeah.
mortgage, for example, for the house I bought, I'm pay in my monthly payments. It includes principal, interest, and taxes. And so the lender will pay the county taxes, county property taxes on my behalf, so it doesn't go to tax deed auction, so their mortgage isn't wiped out. So in our scenario,
Yeah.
sometimes our eyes light up when we see that the lender hasn't paid the taxes. We're like, oh, this is good because that means they probably wrote it off, or they're nowhere to be found. We can probably get this thing wiped out, which creates more equity for the seller. Maybe you can renegotiate the terms of the deal, so it's a win-win for everybody. But that's usually when I'll file a quiet title suit to wipe out that zombie mortgage, or I'll just have an illegitimate lien that someone's filed against the property. Maybe an investor filed a notice of interest or an affidavit of interest against the property 2 years ago, and we both know it's bullshit and it's unenforceable, and they refuse to release it, and they say, oh, I need $20,000 to release this, and I tell them, hey man, if you were going to sue, you would have already sued. You filed an illegitimate lien on the property, you sue them, and you're asking the court to essentially sign an order or judgment striking and removing that lien from the property. And so that's what quiet title is. So it can apply to many different things, but essentially you're trying to remove some type of encumbrance from a property.
Okay, that makes sense. I understand. Okay, and what com I guess, what common title problems have you seen surprise investors?
Notice of interest are big ones because remember, investors, you guys all go after the same leads, the same deals. We'll always see a
Yeah.
recording notice of interest from an investor from a year or 2 years ago, and then a lot of times it's squatters. They'll file a claim of lien for purported work that they did on the property, where they maintained the grass, or they cut the grass, or they made improvements to the property, and they will file a BS lien sometimes. And then also we'll see some fraud, where we'll see that someone executed a fake deed. I did a quiet title the other day. We had a deed, and the notary's signature on the second page, and it was from one of like the owners. Again, it was a probate situation, and I think there was like two heirs, and one of the heirs supposedly executed her interest over to the other sibling, and the other sibling was saying, "Hey, I never signed this. This is fraud. That's not my signature." We looked at the signatures, but what I noticed, and this was our biggest way that we were able to kind of validate it, is that the notary section, the notary has to put their stamp. In Florida, I don't remember how good a notary's license is for. I think it's 3 or 4 years, somewhere in that range. And it was, let's say, it was 2025 when the person signed it, and the notary said that their commission didn't expire till like 2035, meaning it said as if their notary was good for 10 years.
Oh,
So
wow.
we knew that's completely invalid, and that's 100%
Yeah.
fraud. And so if the notary's fraud, that means everything else is fraud. And so we were able to hire a
Right.
forensic expert who looked at the handwriting signatures. I submitted that with the lawsuit. I tried to take the deposition of the notary, and they were so scared they didn't respond. And eventually they folded, but I did file something like that. So to answer your question, notice of interest from other investors, fraudulent deeds, and then usually dumb documents like claim of liens or um, stupid liens filed by squatters or people that think they have an interest in the property, and zombie mortgages.
Okay. Cool. That's interesting. I do want to talk a little bit about this because this is not talked about often, but it happens, and I know, actually investors do this all the time. But whenever there is a notice of list pendant or a notice of interest or whatever filed on a property that for example you have now and you're working and you have assigned and it's going well, and then for example there's a missing signature or for some reason like what are the common negotiation tactics that you do when you're representing an investor that is actually going to get a deal done that someone could not get a deal done before, that maybe it's either legit or it's illegitimate, like maybe there's a signature missing from one of the parties or something like that?
Yeah, I think it kind of goes back to what we were discussing before. Is the first thing you want to identify is who are all the correct owners of the property. So what I always tell the investors is if you know it's going to be a good deal and whoever's handling your closings, you need to have them run a title search, immediately. Because a title search for those that don't know, is the underwriter ensuring that the proposed transaction. They essentially will run a title search. They search the official records, and they have programs to basically verify who the correct owners of the property are. And sometimes, again, if it's a probate deal or it's a hairy deal or there's multiple owners on property, the underwriter will essentially verify, and they're basically saying, "Hey, this is our conclusion. We're willing to back it up and insure it." So you may be talking to these people over the phone, and again, they're not always going to give you the right information. You can only go off of what information these people are giving you, which sometimes is intentionally wrong or just they don't know any better. So I would say it's super, super important to have a title commitment run at the beginning of the transaction or as soon as possible to verify who the owners of the title to the property are. That's super important. That'll help, and then also just being able to do your own due diligence. Search the official records of the county. Being able to read title yourself. So if you search the former owner's property, you can go on the property appraiser's website, and a lot of times they will show all of the deeds or most of the deeds from that property. So you can just click it and then essentially go through title. And what I usually like to do, I have a little file here. This is different from one of Oscar's probates, but I like to draw everything out in a chart. And so if I see that someone became a owner of property in 1975, I put their name, the year, and then I'll put how they held title, and then I draw a chart to help me discern, who the owners of the property are. So all that's free and accessible on the county appraiser's website for the actual property. So that's a good way to help you trace title. And again, it may not be 100% accurate, but you at least have a better idea while you're waiting for the title commitment to come back from the underwriter in terms of who the correct owners of the property are. And then if it's probate, it goes back to what I was saying earlier. You have to know the right questions to ask them and the law.
Okay. Okay, great. Awesome. So, all right, let's talk about trials, appeals, and big cases. All right. There's a little section here. So you've seen cases go all the way through trial and even appeals. How do you mentally prepare for such a long legal fight?
It's hard, man. Something that's not talked about, with lawyers on TV shows is there's a lot of pressure on attorneys, especially before a trial, because it's make or break. A lot of times the client's paying you a lot of money. Trials are never cheap anyways. It's always expensive. There's a ton of preparation that goes into it. I think most people don't understand the time that has to go in to prepare for a trial. You have to prepare all of your questions for all the witnesses in the case. You have to anticipate the objections that the other attorney is going to make and have a response to that. When I say respond, you have to know the specific rule of evidence or the law to be able to respond and anticipate what other parties may ask. You have to assemble all of your evidence, which could be hundreds of documents. There's a way of introducing that at the trial. And again, you have to prepare for the unexpected. You may have someone that completely lies on the stand, and you can't just stop and saying, hey, you're lying. You have to be able to anticipate what can go wrong. You also have to anticipate if the judge asks you any questions. What are they going to ask you? You have to have an answer. And you're there in front of your client usually most of the time of the trial. Usually the clients don't attend anything except for the trial. So if you're charging them all this money, and they stand to make a ton of money, or their livelihoods in jeopardy, or even if it's criminal, which I don't do, you have someone's life in your hands. If you do a crappy job and you don't prepare enough to do those right things, there's a lot of pressure that goes into it, man. So I think the trials that I've done, I don't like doing trials. If any attorney tells you they enjoy doing trials, they're full of it, because it's extremely stressful. And when I prepare for a trial, I cannot work on any other file. I'll have an entire week where my firm pretty much shuts down because I have to dedicate all of my time to the evidence, the questions, the expert witnesses, my opening statement, my closing statement. Again, it's just there's a lot that goes into it, man, and there's a lot of pressure. And the best way that I've been able to deal with it when I became an attorney and I lost my first trial, it was really hard because I had never suffered defeat or loss in a big case for once. And it was really, and again, every attorney wins and loses. There's no attorney that has a perfect record or is undefeated. That's just how it goes. You could pitch a perfect case to the judge or the jury and still lose, or you could have a completely shitty case where your client was wrong and somehow you get lucky. So anything can happen at trial. And it was really hard for me to accept defeat. And I felt like I let my client down. And naturally, you go back and you think, man, what could I have done better? Did I prepare enough? I should have asked this question. And hindsight's always 20/20. Fast forward now, I've done a fair share of trials and appeals. The best thing that I do going into it, and I'm kind of okay with no matter what happens, win or loss, is that I bust my ass as much as possible. I make expectations clear with the client from the start, and I tell them exactly what I tell you guys. I can't guarantee you anything. Here's your strong side. Here's your weak side. The judge is good, or I don't think the judge is great in this particular area. The other attorney's good. He's not good. I tell them exactly straight up. I say, look, I think maybe you got a 50-50 chance or whatever it is. And I do my absolute best to prepare for trial. And then whatever happens, I'm okay with the result. When the result of the trial finishes, I keep my head held high saying, man, I busted my ass. I did everything I could. And if another attorney was there, could they have done something different? Maybe, maybe not. But I have to be okay with living with the result, knowing that I put in the work. And so that's how I've been able to mentally really just handle being an attorney, because you're not going to win every case, you're not going to win every motion, you're going to lose some cases, maybe you make an error or you discover something later. But I think this applies to most professions. If you generally bust your ass and prepare as much as you can, there's only so much things that you can control, and you have to be okay with the result, whatever that is.
Okay. That's amazing. Alrighty. That's very interesting. There's a lot of pressure on you there. But
I don't know if you can see
what
it,
do you?
I had a lot of gray hairs I used to not have. Before I was a lawyer, I had no gray hairs. I just got a haircut on Friday, so my barber helped me out. But a lot of gray hairs come with it, man. It's tough.
Amazing. Cool. Well, you're doing something that's valuable here. So, we appreciate everything. But
Of course.
how do you help your clients understand about the time and cost involved when they head into a litigation? Like, how do you prepare them?
I talk to them as if I was talking to you on a podcast, or as if I was talking to my dog, or as if I was talking just to my best friend. I dumb everything down. I don't use fancy legal terms. I try to break everything down so they understand it. And I think that kind of connects to what I was saying earlier in the interview, why I've been able to have good relationships with my clients, because I give it to them straight. I'm not telling them, oh man, don't worry about it, we're going to win, I'm the best lawyer ever, I've never lost, and giving them all these unrealistic expectations. I always like to err on the side of caution, and I tell clients what they need to hear, not what they want to hear. A lot of clients get frustrated because they just want you to say what they want to hear. And I don't do that. I tell them what it is that they need to hear, and I say, hey man, you got a shitty case. If you want to roll the dice and you want to pay me X amount and you want to take a shot, we can, but I'm telling you right now, I don't think you're going to win. And I break it down and I make it very straightforward and very easy to understand. And then at that point, it's the client's decision. If they want to move forward, great. If they don't want to move forward, great. Either way. But I do my best to give them the best idea so that they can make the most educated opinion on whether they want to proceed or not. And in terms of costs, risks, etc. And also, again, the same thing, I live with it. And I tell them, like, look, I'm here to do my job. Barring something catastrophic, I'm going to do what you tell me to do. However, here's my opinion, here's what I recommend. You don't have to listen to me, but don't come crying to me if we lose and you say, oh man, you didn't prepare me, or you didn't tell me that, if we lost, we face this type of exposure. So I also do that to cover my own ass, just to say, hey man, I told you exactly what you stood to make and what you stood to lose, and the decision's up to yours, and you have to be willing to accept that. So that's how I approach the clients, and most of them, they appreciate the straight up approach, because a lot of other attorneys, they like to be in the middle. I don't know, it could go either way. I don't like doing that. I like picking a position and sticking to it, and just being confident in my answer or my recommendation.
Stud. Yeah. Okay. Cool. All right. So you worked with high-profile clients. You worked with NFL players, boxers, and wealthy individuals. What's unique about handling their legal matters?
Yeah. So I can't disclose specifics in terms of what I help them with, but I can tell you I help them with estate planning. And so the biggest goal with them, one of the guys who was cool with me disclosing that I helped him was Andre Johnson. So he was a receiver for the University of Miami, played for the Texans in the NFL, and actually was just elected to the Hall of Fame. Super cool guy. And so I was essentially helping him and some other athletes with their estate planning, meaning they have a ton of assets, they have a lot of wealth. How can we ensure that it doesn't have to go through probate if they die? Because if their stuff has to go through probate, most attorneys, when you have a big value of the estate, they take a cut of the value of the estate, usually 3% or even higher. And so it would be a disaster if they have 10 houses, 20 cars, stocks, bonds, retire, all this other stuff. If it has to go through probate, it's going to take forever to get to their beneficiaries. The estate's going to have to pay probably hundreds of thousands of dollars on attorney's fees just to transfer all of those to the heirs. So the goal is to help them that if they pass, everything doesn't have to go through probate, doesn't have to go through the courts, and goes automatically or through a restricted distribution to the beneficiaries that they want to go to. And the second part's with asset protection. So obviously with athletes, they're going to get sued for any little thing. Slip and fall, sexual harassment, whatever it is, because when you're someone that has money and power and an image, you're going to get sued no matter what. Whether even if you're the best person, you never committed a sin, someone's going to sue you for something looking for a payday. And so you have to anticipate litigation. So there's certain ways that you vest title to property, whether it's in a land trust, or perhaps if you have a different family member, hold title to the property. So technically you live in the house and maybe you pay for it, but it's not under your name. And so there's some techniques that I can't go into full detail with, but our goal is to essentially protect them that if they get sued and on their worst day in court, they don't settle, they don't lose, they lose in court, it's going to be much more difficult for the person that's sued to actually enforce that judgment against them and recover money on the judgment.
Awesome, awesome. Okay, cool. So, all right. So for anybody that's listening that may be a high net worth individual, what's your go-to advice for them when it comes to estate planning and long-term protection?
Your goal should be for all of your assets to go to whatever beneficiaries that you want without having to go through court. Well, again, when it goes through probate, it opens the door to creditors. If you have creditors, they can file claims against the estate. You can have beneficiaries fighting each other. It's just, you never, whether you're a low profile individual or high profile, you don't want your assets going through probate, and you should consult with a good asset protection attorney. It doesn't have to be me, it could be anybody, whoever it is that they want. And you want to anticipate litigation. You want to have all of your stuff set up before the litigation hits. You don't want to have to then, because if you for example, let's say this person X gets sued and he's worth $100 million. And after he realizes he's getting sued, he moves all of his assets into a trust, or he transfers title of the assets to his mom or a family member in an effort to try to say, hey, look, I'm broke, I don't have any money, I don't own any assets. In litigation, there's a Florida statute that has a look back period, meaning the court, once a judgment's entered and the opposing party, they can look back at all of your banking transactions, your real estate transactions from the time of when the judgment was entered in the case versus when the lawsuit was filed and even before the lawsuit was filed. Meaning they can go back and say, okay, did this guy literally dump all of his assets after he found out he was being served with the lawsuit? And if that's the case, and that can be established in the court, even though those assets aren't owned by that same person and they're owned by a family member or whoever it is, the judgment holder can use that judgment and then still go after those assets, even though they're owned by someone else. So you have to be very strategic, and I always tell you, it's better to be proactive. Get all your stuff done correctly so that hopefully the day never comes. And it's a little bit of a pain in the ass, because the way that I structure it, it requires a second and a third prong to do things and just do your day-to-day business, and it's a little tedious. But the trade-off is, if you get sued, you could say, okay, good luck. We're protected, we're good. Whereas if you don't do all that and you wait to do it too late, you're in trouble.
Amazing. Okay. Cool. All right. Well, let's talk a little bit about your personal and professional life. So you stay on top of a fast-changing legal world. How do you keep yourself sharp and up to date, with everything that you do?
Yeah. So what I've done even when I was younger and before I became an attorney, YouTube is a beautiful thing. You can learn really anything. I won't say anything, but you can learn so much stuff on YouTube for free. What I always enjoy doing is I'll look up high-profile cases, and a lot of those, like the OJ case and Casey Anthony cases, and I like to study my craft. The best way to become a better attorney is copying or learning from other attorneys, and this is the same thing in any profession. You want to learn from people that have been there and done that before you. So I will go on YouTube for hours when I have free time and just watch trials and see how attorneys made their opening arguments, their closing arguments, what questions they asked. And then sometimes too, most of our court hearings are through Zoom nowadays, which is great since COVID happened. When my hearing's done, or when most hearings are done for the attorneys, they usually just leave and go about it. Sometimes what I'll do, if I see that there's a couple of fiery cases and some good attorneys, I'll finish making my argument for my case, I'll mute myself, I'll turn my camera off, and I sit and observe. And even though I've been an attorney for 6 years and I've really been in the industry since 2014, I'm never going to say that I am too good to not learn something new or to learn from another attorney that's been doing it longer than me. So I will just sit there in those hearings, which are available to the public, and sometimes just watch and observe other attorneys and see what they argue, see what their defenses are, see how they speak to the judge. So I'm always trying to continuously evolve my craft. I'm never at a point where I'm saying, man, I've been there, done it all. There's nothing more you can teach me. There's no other way I can improve. So I have no problem putting my ego aside and just really learning from other attorneys. I order a ton of books. You can just get a ton of books that are written by attorneys about how to ask questions at depositions. There's books written by a lot of Supreme Court justices that retired where they talk about shady attorneys and good attorneys and how to make persuasive arguments. So it's really just continuing education. And it's taking pride in your craft. And I encourage whoever's watching, you don't have to be an attorney, whether you're an investor or you're doing banking or real estate or whatever it is, take time or spend the money to learn from other people that have done it. And the resources are there. And sometimes you don't even have to spend a ton of money on, just go on YouTube, and there's a lot of resources that you can learn. But no matter how long you've been in the game, you should always be trying to continue to evolve your craft and continuously learn.
Amazing. All right. That's cool. And What about your daily habits or practices help you manage the stress, from your high stakes cases and work life?
When I first became an attorney, it was exciting. I was poor my entire life. I grew up with a single mom. My parents were divorced when I was 2. He moved away and never paid any money for child support. My mom was a teacher, not really making all that much money, and somehow managed to put us through Catholic school and try to give us the best chance of becoming successful. So I grew up poor, not to the point where I was living on the streets and had no food. We had a house over our head, and God bless my mom, she did her best, but I never had any money growing up, and that went all the way through to becoming an attorney. I was making $10 an hour, etc. And we got to the point where, when I first became an attorney, again, I started making okay money, which was sexy. It was fun. And I was working 7 days a week, but what I wasn't doing was making time for myself. I stopped going to the gym. I wasn't eating healthy food. I was ordering out every day, or just Uber Eats, or going out to restaurants with the partners. And as a result, I became in really bad shape. I was pretty heavy. I put on a ton of weight. I was drinking a lot, just to cope with the stress and the anxiety and everything else. And I wasn't making enough time for myself and my physical fitness and my mental health. And that went on for a couple of years until I had to kind of put my foot down and say, man, like, this isn't good. Sure, I'm making a lot of money. Sure, I'm becoming successful, but I am getting punished when I go to home. I'm not there. I'm letting myself down, and I'm putting too many people in front of me and letting my career take too much. And I'm not putting that fine line in the sand saying, okay, I'm done with work. I need to focus on myself, my relationships, my friends and family. And so what I've been doing recently over the past couple of years, which has helped me a lot, is I refocused on my fitness. By no means am I a bodybuilder. I don't count my calories. I don't eat salads for every meal. But I try to eat at least somewhat healthier. I actually recently stopped drinking alcohol for the past 2.5 months. That's helped tremendously. And I really got into running, believe it or not. I used to hate running with everything I could possibly think of. I didn't enjoy it. But now I've become addicted to running. I run 3 to 4 times a week. I started my own run club with one of my buddies here in Cooper City. Every Saturday morning, I'm up at 5 in the morning setting up the course with my buddy. We meet up during the week. I have my own fitness with the gym. And what I've realized, and I think what I'm saying here translates to anybody in any profession, especially young guys like us. It's incredibly important to take the time to focus on yourself and your mental health. Whether it's basic meditations, practicing breath work, gratitude, writing in a journal every other day, just kind of what happened in your life, how you felt, good things, bad things. I don't think anyone's required to have a type of religion, but whatever it is that the person prefers, I think it is nice to have some form of religion or some type of faith to where you feel like you have a little more purpose in life and you're doing things for the right reasons. And honestly, man, I think going to therapy and even seeing psychologists, it's especially amongst men, it's not talked about enough, and we have to deal with a lot in life and society and being the providers. And it's okay to ask friends or family for help or to ask questions and to learn. And if it means seeing a therapist or whatever it is, there's nothing wrong with that. And I'm happy to admit that because it's helped me a lot. But if you were to ask me years ago, I wasn't, I was scared, to admit that. Like, man, maybe I need to talk to somebody. And so I think as men, it's important to do that. But going to the gym, any type of fitness, I think is crucial because it gives you natural energy, endorphins. You look better, you feel better, you eat good. Naturally, you're going to feel a little better. So I really focused in on the fitness, the running, and then also taking care of my mental health and journaling, practicing breathing techniques, and a lot more gratitude. Because I would go into work saying, man, this day is going to suck. I got so much work. I got to deal with this client, this attorney. Like, this is terrible. I'm having such a terrible day. And I learned to refocus that and say, man, I run my own law firm. I'm making fantastic money. I have people that are choosing to bring their money and their business to me when there's a million other attorneys that they can bring that business to. And I think back to when I was a paralegal, making $10 an hour, driving from my mom's house, waiting at the train, sweating my ass off at the shuttle. I say, what would Gio in 2014 think of Gio now in 2025? What would he say to you right now? And so I think it's important to change your focus on life and work as opposed to saying, man, I have such a crappy day. There's so much crap. Change that. I'm blessed to have a roof over my head. I'm in good health. I have an opportunity to help people, to make money, to do well for myself, and I've worked very hard to get to the point I'm at. And I can't forget where I came from. So I think perspective on daily things makes work a little more enjoyable and feels like you have a little more purpose, as opposed to obviously being stressed out and just saying, man, this is terrible. I'm having just such a bad day. Like, oh, it's gonna suck. Mindset is crucial in how you approach things.
Amazing. I love that. And when you think about your legacy, like what do you hope to leave behind through your legal work, or you know?
Yeah, it's a great question. My hope is that if one of my clients, someone reached out to one of my clients, the best thing I can hope for is that they say exactly what I would say. Gio is always honest, reasonably priced, worked his ass off, got us the best results, and I would never want to work with anybody else. He's my guy. And obviously, and I think for me personally, it's just making my mom proud. Based coming where I was at, growing up without a father, she worked multiple jobs, just to put us in Catholic school because she was a public school teacher. She didn't want us to go through what she saw as a teacher. And so I
Yeah,
think, sure, it's great for me, to accomplish things, but I always forget, or I always remind myself, make sure that my mom's sacrifice and hustle and all the crap that she had to go through wasn't for nothing. She hustled just to put me in a position to give me an opportunity to succeed. And she did. And I need to take advantage of that and make sure that her grind and hustle for all those years, as a single parent, busting her ass, working multiple jobs, having no social life, just to give myself and my sister a shot to become successful and have a better life than she did. I cannot let that go down the drain. The least
for
I
sure.
can do is be the best version of myself, successfully, career, professionally and personally, and just to repay her for everything she did. So that's what gets me going, and that's what I want for my legacy, is to be able to do that for her, and then obviously pass that down to my family, whenever that time comes.
Amazing. All right. Awesome. So let's wrap up. I want to do a little rapid fire, section for tips for investors. So just feel free to chime in little tips here that you think would help. Um, so what are the top legal risks real estate investors should be watching for right now?
In what area specifically?
Well, when it comes to doing deals, like wholesaling deals or whatever, anything that's dealing with specific performance or breach of contract.
Okay, for specific performance, you're suing the seller saying that you did everything you were supposed to do under the contract. What that means also is making your escrow deposit. The first thing that every defense attorney says to me after I sue the seller is, did your client make their escrow deposit in time? If the buyer did not make their escrow deposit in time, there's a high chance you might not win the case, because you can't sue the seller saying that they breached the contract and you did everything you were supposed to do when you didn't
Hmm.
make your escrow deposit. So I see
Okay.
that so many times, and I tell people, I'm like, man, you spend all this time and money. If under your contract it requires you to make a deposit within a certain time, make the damn deposit, because
Hmm.
that's one of the only not one that's the biggest defense that I see from other attorneys. And once they do discovery and they find out that you didn't make your deposit, it's a really uphill battle to win on that case. With respect to probates, one of the first questions you should ask any heir is, was the property the homestead of the decedent? Homestead meaning, was it the primary residence where the person lived at when they died?
Hmm.
The reason being is that all of the heirs or beneficiaries have to sign your AB contract and have to sign all of your closing documents. A big misconception with investors, they think, oh, all I need is a signature from a personal representative on my contract. They're the person that's in charge, they're the named personal representative in the will. I only need them to sign my contract. 100% wrong. If it's homestead property, the personal representative does not have legal authority to sign any documents on behalf of the property if with respect to the homestead property. You need all the heirs or beneficiaries. An heir is someone that inherits something through the law when there's no will, and a beneficiary is someone that was specifically designated to receive something under a last will and testament.
Amazing. So what specific things on contracts or documents should always go before when doing a deal?
Mhm. I always one of my clients has a good language in there that essentially says their deposit isn't due for 5 days after the inspection period closes. Reason being, when
Okay.
most investors have it under contract, during that inspection period, they're trying to find an end buyer, during that time.
Hmm.
So if you're required to put up your deposit before, you're going to be out a lot more cash flow if you're putting deposit up. Or a lot of times other investors use their end buyers deposit, which is not really proper, but that's a discussion for another day. So the reason that we put that their deposit was due 5 days after the expiration of the inspection period, that basically gives my client as the buyer or investor time to lock in the end buyer, and when they know for sure they got a deal, they'll either use that end buyer's deposit on the assignment of contract and their AB contract, or they can put up their own deposit on the AB contract. And then if the seller decides to breach and you have to sue, you can say you put up your deposit. But generally speaking, once the inspection period ends, you can't really cancel the contract. You're on the hook with moving forward as the buyer. So at that point, you're going to know whether you need to make your deposit or not. So it's better if your deposit's due within 5 days after the inspection period expires, as opposed to your deposit being due prior to the inspection period expiring, when you don't know if you're going to move forward with the contract or not.
Okay, amazing. And what small when small disputes pop up, what's your advice for handling them before they get into bigger legal issues?
Usually, I'll have a lot of investors. They'll want me to send a demand letter to the other side. I always think it's better to get an attorney involved quicker, because you're showing the other side that you're being stern, you're not messing around, you're not playing games, and you're ready to spend some money and take it to court if you have to. I'm not telling you to be overzealous or just sue anybody for anything if they look at you the wrong way. But at the end of the day, this is a business. If you stand to make a lot of money, it's always great to get an attorney involved. It's better to be safe than sorry. Have the attorney get involved and take things from there.
Amazing. And last but not least,
don't be cheap. That's my last thing. My buddy Will. Don't be cheap. If you stand to make $20,000, $30,000, $40,000 on an assignment or whatever it is, and the attorney charges you a couple $1,000, don't be cheap. Don't ask for discounts. If you're getting a great service and the attorney is going to help you win the case or preserve the deal, which means you're going to make 20, 30, 40K, do not be cheap and complain about attorney's fees. If you do, no attorney is ever going to want to work with you again, or you're going to ruin that relationship. That's my buddy Will and Oscar will echo that. And what I love about them is they don't ask questions. They know the level of service that I provide, the return that they're getting, based from getting the lawyer involved. And most times, and I'm not speaking for every attorney because maybe an attorney charges too much, but don't be cheap with your vendors. If someone is, and this is a good business tip, if someone is providing you with a good service and it's someone that you're going to go to repeatedly that's going to help your business, don't be cheap. Value their service and pay them what they're owed. And pay on time.
Amazing. Awesome. All right, and last but not least, what advice would you give to someone who's just starting out in real estate?
Invest in your education. Whether it's having a mentor or a coach, obviously you're going to have to give up a lot of your profit on your first couple deals. But if you try doing all this yourself, it's going to take years and years and years to learn, and years and years and years to make mistakes and to learn from your mistakes. With a mentor or a coach, you're paying for what you get. You're learning from their experience and you're speeding up your timeline. And William Dennis is a great guy to learn under, but it doesn't have to be him. It could be whoever it is that they want to go to. Spend the money to invest in your education. It's like school. The more you know, this is your craft. Watch YouTube videos. Spend money. Invest in your craft to become the best version. Don't just sit there and think you're gonna make a ton of money just cold calling people getting deals under contract. That's not going to happen. There's hundreds of thousands of other investors in Florida doing the exact same thing. What's going to separate you from that other investor on the phone? Your knowledge of the game.
Okay. Amazing. All right, Gio. So where can listeners reach out to you to connect with you or learn more about your services?
Sure. Email is the best, just because with phone calls, I'm either in mediation, deposition, court hearings. It's hard to get a hold of me sometimes. My email is my first name, Giovanni, Giovanni, @GVB. So that's Golf Victory Bravo -law.com. And if you just Google my name on Google, you'll see my website. It has all my contact info on there as well.
We're going to put it in the show notes, guys, so make sure to look for that. All right, well, Gino, thank you for joining us and sharing so much wisdom today. You've given us listeners a real behind the scenes of what it looks to be in the legal side of real estate and probate. And for anyone who wants expert legal help, make sure to connect with Giovanni. And thanks again.
Thanks, man. I appreciate you having me on.